Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. In this video, we are going to discuss the case law on section 139 of the Negotiable Instrument Act. Normally, you are filing a case under section 138 and 139 draws the presumption. We are going to discuss that presumption in this particular case. Honorable Justice D.Y. Chandrachud and A.S. Bopanna, while deciding the case of Oriental Bank of Commerce, presently the name is changed, Oriental Bank of Commerce versus Prabodh Kumar Tewari in criminal appeal number 1260 by 2022, dated 16/8/2022, held that the person who hands over the signed check, if it is signed by him, even though the gaps are filled up by somebody, yes, the presumption is that he has given the check. He is liable for the amount of the check unless he proves that the check is not given for the particular liability. You might have understood the crux of the case. Here, Oriental Bank of Commerce, actually they went in appeal to the Supreme Court against this Mr. Prabodh Kumar Tewari. What he has done, better to know the facts of the case. So this Tewari and others, they started different companies in the name of Pixian Media, Pixian Vision, etc. and availed a loan of around 11 crores or so. They have become defaulters. They have to pay the money. So, as a token of the liability, this Prabodh Tewari, he has given a check bearing number 387212 on 26/12/2011 for an amount of 5.57 crores to Oriental Bank of Commerce. Actually, this check was given in other branch. His account branch is other branch. So, as usual, these bank people, they have sent it to the account branch of this Prabodh Kumar Tewari. Usual reply: insufficient funds. So, even though he gave the check, the funds are not there. As such, it was bounced. So, naturally, what they will do? They have to file a case. Yes, the Oriental Bank of Commerce, they have followed all the procedure, like giving a notice, waiting for some time. Ultimately, after 45 days only, they have filed the case. Now, the point is, Mr. Prabodh Kumar Tewari, he contended that the gaps are pay so and so amount to so and so, all these things. These gaps are filled up by somebody. And what about signature? It is his signature. That means he said that he lost his check signed by him and it has been filled up by the Oriental Bank of Commerce people, or they have forcibly taken check from him, they have filled up, and therefore he is not liable to pay the money. Right? When this contention is there that the check has been tampered or this check has been filled up with other persons, definitely, so it has to be sent to the handwriting expert. So he has filed a memo. Ultimately, the court allowed him. Therefore, the Oriental Bank of Commerce went to the High Court. High Court said, yes, when there is a dispute, when these people are saying that the gaps have been filled up by some other ink or some other person, then definitely we have to get it examined. So, against it to this order of the High Court, the Oriental Bank of Commerce approached the Honorable Supreme Court of India. Now, Honorable Justice Chandrachud and A.S. Bopanna, they clearly stated that the respondent signed and handed over the check. This is admitted. Right? During the cross-examination. So, he signed a blank check. And now the point is whether the High Court is correct to send it to the handwriting expert to decide the details, whether the details were filled by some XYZ. So here section 139 plays a major role. Section 139 of the Negotiable Instrument Act says that, please remember, it draws the presumption that the drawer handing over a check signed by him is liable. unless it is proved that the check was not given in the discharge of the liability. Evidence of the handwriting expert will in no way be useful for the particular case. So it is not to determine whether the signed signature is that of Prabodh Kumar Tewari or not. It is the dispute regarding the filling of the blanks. So whether A has done it, B has done it, or C has done it is not bad. Whether he is liable for the check amount or not. Number one, whether he has given the check as a part of the payment of the liability. If that is there, yes, even though the gaps were filled up by some other person, this man is held liable because he issued the check for the liability. So if it is proved that this check is lost, this check is missed, then there may be something he can go for some other defense. But as far as this case is concerned, he has stated that he has admitted that he has given the check as a part of liability. Therefore, the other points need not be filled up. And once he signs the check, definitely he is liable to pay the amount. So therefore, he is liable under section 138 of the NIAct. So please remember the provisions of section 138 and 139 of the NIAct, because lot of cases are coming up, and in Ongole town itself 7,000 cases are pending. So please remember the value of the economical frauds. So definitely as an advocate you have to light up all these judgments, and definitely you can pick up. Normally in 190% of the cases they will just sign the check and give it to you. Other items normally you are going to fill up, so don't bother. Here this judgment will be helpful for such persons. Okay, thank you.